All right, we're back for the last discussion of the day. And today we're looking at some other discussions under artificial intelligence and contemplating some of the concepts that we have heard about under consideration in other states related to artificial intelligence. And this is just a general discussion and an opportunity for public comment and to weigh in on these topics. The topics that we've been looking at, Mr. Co-Chairman, include regulating AI liability, data provenance, we had a bit of discussion on, and automated decision-making issues related to artificial intelligence. And this is an opportunity to maybe hear a little bit more about that, discuss it as a committee, and then contemplate whether we want to have any legislation drafted at this time or to continue learning about those topics as we move forward. I know that Mr. Greenwood was going to provide us with some testimony and weigh in on these and potentially other artificial intelligence topics. So I think if he's available, we can start with that discussion and then look for other public comment and go to the committee for discussion. So Dazza, welcome. We appreciate once again having you here. If you'd reintroduce yourself, that would be appreciated. But again, you know, we welcome the opportunity to hear from you on what you're hearing from your colleagues in studying emergent artificial intelligence policy and regulatory issues, and particularly again with regard to liability provenance and automated decision making, if you're hearing anything that we should be contemplating. So with that, the floor is yours.
Thank you, Mr. Chairman, members of the committee. I am Dazza Greenwood, and I am Executive Director for the MIT's Computational Law Research Group. That's law.mit.edu, and I run civics.com. That is a consultancy that works in the area of legal engineering. We're basically creating technology systems that conduct legal tasks and processes. And so, as you can imagine, generative AI in the questions of liability and automated decision making comes up a lot. And I would be happy to share some observations about how it's coming up and some thoughts for areas that could be ripe for state legislation. So the first thing I'll say is I think the area that's most ripe among the three topics that you mentioned with automated decision making, provenance of data, and liability for AI systems is actually the automated decision making technology. There's a number of statutes and regulations that have already started to address that. So I'm going to focus more on that, but I do think that it's closely related to the liability question. With provenance is sort of another topic, so I'd like to just separate that out. The first thing is just defining automated decision-making systems. And broadly, it's when you've got some machine system that uses data and algorithms to make decisions. And then where it gets a little bit different is some approaches are where there's minimal human oversight and review, and others are where there's zero human review or approval. And they encompass a broad range of technologies, and they occur in really virtually every context in the economy and society at this point. Some of the harms that are discussed with systems like this, or in the policy context at least, are perpetuating bias, that has made its way in through the training data, for example, or the way the systems have been coded, eroding transparency about who decided what and when and why. And one that I would sort of add myself is just general over-reliance. I am a big proponent of leaning on these technologies to conduct transactions and other systems faster, cheaper, and better. And when it comes to generative AI, especially the top models, I think one of the biggest problems is that they're so darn good. They get many things right, and it looks very finished. And there's a temptation to just take the outputs of these models and put them forward as a finished work, like to third parties, to consumers, to citizens, to other businesses. And that can be a problem because the technology does have flaws and it does have limits. I testified a while ago now on the Dow LLC about the tragic example that's happening in the UK now with the post office and the over-reliance on a financial accounting system that was supposedly spotting fraud and the resulting prosecutions of local postmasters, several of whom went to jail. Many lives were ruined. One of them committed suicide. It was really tragic precisely because it was totally bogus. The system was flawed. And the post office and the Crown prosecution over-relied upon the system and did not listen to the pleas of innocence on behalf of the people that were prosecuted. And now it's become a big deal. There's been parliamentary hearings and, people's convictions have been overturned. And, there's tribunals to try to find accountability within the post office, which is tough in that bureaucracy. But the point is, it's very tempting to kind of have our own bias in favor of automated systems. And, this isn't new to generative AI, but I think it's going to be exacerbated by generative AI because it's in many ways better than the prior technologies. And so I think that's a real risk in this context. These automated decision systems come up a lot in banking and finance, and they have for a long time. Criminal justice, like sentencing guidelines, there's algorithms for that now. Advertising, like new ad tech, is fundamentally a huge automated decision-making algorithm that decides, what offers you'll get and broadly what opportunities you may have. Also, there's tracking issues. It's coming up, as I said, in every part of the economy. And the way jurisdictions are starting to handle this, I think, is instructive, but I also think it's incomplete. So I now live in California. I'm learning California law. There's a lot of it. And I think the California Consumer Privacy Act and the CPRA that had some amendments are probably the best example of granting consumer rights in automated decisions, including opt-out and explanations. And there's also some very complex regulations that are floating around now as part of a notice of proposed rulemaking with more definition on that. Colorado, Connecticut, and Virginia also provide consumers with opt-out rights for what they call profiling as part of these systems when there's a high-impact decision. Texas grants opt-out rights, but only for fully automated processing, so the kind where there's no human review and approval that I'd mentioned. Delaware, Indiana, and Montana combine opt-out rights with data protection assessments for what they call high-risk automated decision-making technology systems. And at the federal level, there's the main thing is there's a proposed Algorithmic Accountability Act, which is making its way through the legislature. Nobody is betting on legislation at this point, but it's a good example, and it's going to come up again next session. And it would regulate automated decision-making across many sectors. FTC is also pursuing this. They've had hearings and floated some rules. So, it's out there. And I think, the themes are transparency, accountability, and consumer rights. But as I mentioned earlier, I think the current approach is incomplete in terms of how automated decision-making technologies emerging now because of generative AI. And what we're seeing now isn't just like big enterprise systems that are performing, like welfare benefit determinations as part of like a big platform, but or banking systems doing loan origination decisions and that sort of thing. We're actually seeing a lot more interesting, smaller applications that are bespoke. And the wrapper, the term that is used for this is agent. Automated agent or autonomous agent. And there is a huge number of startups now and larger companies that are providing products and services that are, like I would kind of say, the category I would call it is agentic AI systems. So they're fueled by this generative AI that can look at interesting novel circumstances and apply rules and do reasoning of some type and give you an output in a standard format. And it not only can make some of these existing transactional processes faster, better, cheaper, but it actually can do whole bunches of new things that we could never do in automated ways before. So it's starting to open up new business models and new markets. And the main thing is that the issues when you look at autonomous agents are a little bit different than when you're looking at like the kind of regulatory scope for automated decision-making technology. It's closer to what David Pope testified to not too long ago, when he's saying, what about the situation where there's some system and it's making determinations purportedly by me about financial statements. So I think he said like Enron's going to be solid for 10 years or something like that. That came up in the context of someone, kind of weaponizing the system against David, I think, because of the prior discussion on synthetic media. But the way this is coming up a lot now is people are choosing to use these systems to conduct transactions on their behalf, kind of paperwork and other stuff too, and it's coming up with outputs and decisions that may or may not, be in their best interests, and especially when there's third parties involved. So, like in David's example, he's doing a filing to like a regulatory agency, presumably in that case. That's where this automated decision making in an agentic process raises particular liability and public policy questions. And again, I'd say exactly in theme with my prior remarks, I think existing legal frameworks can carry us a really long distance in looking at this novel technology and some of these relatively new use cases. And in particular, I'm thinking about the Uniform Electronic Transactions Act, which, as the committee knows, Wyoming has. It actually has a section that's titled Electronic Agents, and it's defined in your law as a computer program or other automated means used independently to basically conduct transactions in whole or in part, quote, without review or action by an individual. So it's exactly what we're talking about. And part of what's great about just looking at this existing legal framework is it has provisions for attribution. So like, what legal party or parties are responsible for the actions of this automated system. And that's where you can start to get to allocating and attributing liability, things like that, and transparency. And it also has some great provisions for error prevention and correction. UEDA, one of the issues is there's a bug in the system or it did something that was unexpected. And then if you kind of find out later when you get the receipt or the thank you for your transaction, it provides you a period of time to go and correct that error. So UEDA is a great existing legal framework that can be applied to a number of the issues that arise with automated decision-making when it's being used more broadly through these AI systems. And in closing, just a few thoughts where there may be some gaps, I think, are one thing is, it's one thing to inform people that a decision has been made by a automated system, but I feel like for that to be usable by people or businesses, when these things are B2B, some sort of tracking number, that says like this was the decision, would make it much easier to follow up and ask for more information, to perhaps ask for human review, something like that. So that's something where I think, in implementation, having a general statement buried in the terms and conditions or a general alert at the bottom of a page that automated decision-making is happening somehow is, probably going to fall a little short of achieving the intention of having some rules on this about attribution and allocating liability. And the other thing I sort of hinted at it, but in some cases, I think before people go to court, just being able to click a button or request human review for some high impact or high risk or, some existential kind of decision that was made by a machine might be a very nice interim step that could be appropriate for legislation. And finally, I'll just say many of the people in the group of experts I'd assembled for the committee on the generative AI session, the sort of educational session a year or so ago, are also we're collaborating on a joint initiative between MIT and Stanford, looking specifically at agentic AI systems, because there's a ton of startups coming out of our schools that are doing this, and it's a big part of what's happening legally with generative AI now, and we want to get ahead of it a little. And I would just offer, if it would be of use to the committee, to assemble some of those same people that testified before and some other heavyweights that we have to provide maybe more considered and complete remarks on what these systems are and the benefits and the risks, and some potential ideas on the application of existing legal frameworks or tweaks to those frameworks for the legislature to consider when you're dealing with the advent of automated decision-making systems. So that concludes my remarks. I want to thank you for your attention.
Thank you, Mr. Greenwood. That was excellent. Appreciate it. Mr. Co-Chairman, question?
Thank you, Mr. Co-Chairman. Dazza, I really appreciate that testimony. It was very thought-provoking. And, when you kind of talked about UITA and some of those provisions, it kind of made me think about some of the language we have around fiduciaries, right? And how you're legally obligated. Do you think that how applicable is that analogy, would you say, in this type of scenario? I'm sure it's limited to some extent, but what do you think?
Dazza?
Thank you, Mr. Chairman. Mr. Co-Chairman, Representative Western, I think it's completely applicable. And in fact, I've been working lately with the Consumer Reports Innovation Lab and others, and they're extremely interested in the use of agentic AI by individuals and consumers to help them as they're interacting. So that's sort of their angle on it. And in the last kind of prototyping session we focused a lot, interestingly, not on code and protocols, but on law. And we looked particularly at the fiduciary duty of loyalty and the fiduciary duty of care. And for loyalty, what we were looking at was cases and kind of a law review articles that defined the duty of loyalty in a way that we could derive technical requirements and constraints from, so that we could see if we could start to build those types of behaviors into the agent systems that Consumer Reports is starting to prototype on behalf of the consumer in this case. And that really helped get us further to making sure that the system didn't produce anomalous, kind of surprising outputs when the consumer discovered what it did later. So this duty of loyalty is a great one from fiduciary duties. I think there's a lot of other fiduciary duties as well that could come up in various ways. The main thing, just if you kind of zoom out, other than that anecdote, is when people in business, especially small businesses and consumers, are dealing with agentic systems, it's seldom at this point in history their own system that's doing things on their behalf, although that's increasing. It's someone else's system that's doing things with them, or arguably to them in a way. And so that people may not be aware that the system that they're interacting with is not operating on their behalf, in their best interests. It's operating on behalf of a different principal, and principal, PAL, a different boss. And so you can kind of cure some of that with disclosure and things like that, but at some point making sure both parties have agents with capabilities to engage with each other is, I think, where this is going to end up. And the fiduciary duties, or the equivalent of them, will be owed by those agents back to the party that's deploying that agent, and then they'll sort of fight it out.
Follow-up, Mr. Chairman?
Thank you, Mr. Co-Chairman. I do. And as I appreciate your kind of extrapolating that concept. The other thing you mentioned that I found kind of fascinating was, that tracking number for decisions. The same way we've gotten really good at tracking packages from Amazon. Conceptually, it's the same thing for AI and AI decision-making, where if it makes this decision, that decision has a tracking number, and it can be audited and go back and look through the logic, the principal logic that these algorithms used. How practical is that idea in terms of putting that into legislation of, if you're serving customers interstate, you have to be able to track or audit or have a tracking number for these decisions?
Dazza?
Thank you, Mr. Chairman. Mr. Co-Chairman, Representative Western, I think it's fraught So I offer that as an initial thought of an area that could be useful. I think it would be incredibly useful to have such a thing. I think there's a million ways to go wrong and to prematurely regulate or over-regulate or, impractically regulate. And yet, I think as the committee, as the select committee matures its understanding and starts to look at drafts and things in this area, if you do, eventually I think that you'll come to look at distinguishing different kinds of decisions, and some of the high risk, high impact, mission critical, high value, very sensitive, that kind of category of stuff, may be appropriate for somewhat for a few more requirements. And I just, just having built a lot of systems and engineered them and then went with companies and governments when the systems go wrong and try to remediate them, I just know tracking numbers can be a really handy tool, but used sparingly in the right, like targeted though to exactly the right thing. And I believe it's premature to specify that at this time, but it may be a good tool, a good arrow in the quiver when the time comes.
Anything else, Mr. Chairman, at this time?
Not right now.
Okay. Des, I have one quick one. Well, first of all, let me go to the committee. Representatives, anything for Mr. Greenwood at this point? Do we see any hands from the committee online this time? Okay. Then, Mr. Greenwood, one maybe lower hanging fruit. We heard circumstances in the past of states using AI or algorithms, probably more likely algorithms than anything that's particularly advanced AI, for what would effectively be high stakes decisions. I think you mentioned one with regard to corrections. There's concern with that. And what have you seen any states that have tackled this head on with either having a set of requirements or a human in charge, a human review, something along those lines? Do you see any legislation out there or best practices that we might want to consider with regard to state decision making using algorithms or AI?
Mr. Chairman, I haven't done a review, to be honest. I've sort of anecdotally, some people send me things and I see things in, the news like everybody else, but I've not gone deep into the sentencing guidelines and the other corrections contexts. And so I'm afraid I don't know. However, it is on the deliverables list for that experts group I mentioned from MIT and Stanford. So I assume by your next hearing in September, we'll all know a lot more, at least in my group, on that topic. At a high level, I think two things, just kind of off the cuff. One of them is humans. I feel like for sentencing and depriving people of their liberty, a human really should be reviewing these things and be accountable to them prior to it just being rubber stamped in some way by a tribunal. And the other is that I would love to see a system where every defendant, no matter what their means were, had readily available, high quality algorithmic systems of their own that was tuned to the sentencing guidelines and to their circumstances, and it maybe had different merit order algorithms so that they could make the case to the same tribunal as to why they should have maybe a different sentencing outcome. But I think this technology is powerful. It's powerful for law and justice. And for our system to work, our adversarial system, both sides need access to the same technology. And then, the crucible of the adversarial system at the end will mete out justice, we hope.
AI battling AI, right?
I think that's where it's going. Yes, sir.
Yeah. So one of the other areas in addition to sentencing was provision of benefits, healthcare benefits, for example, or Medicaid, where eligibility levels were being decided by algorithm, and so decisions related to the availability of benefits to individuals were apparently automated. And again, you have a high stakes decision where there might not have been a human getting involved in the process. So you can imagine 1 month you are covered by Medicaid, and the next month you are suddenly not covered by Medicaid, and a computer has made that decision for you. That's another area of potential concern, getting back to what would a best practice for government be, and how would we potentially draft that, where you have a decision of that magnitude, how do we get a human involved? And the other aspect of it is, how do we get a human involved objectively, where they're not just saying, yeah, that looks good, I agree with the algorithm. Is that something that your groups are going to be talking about, maybe working through? Because I do think that's an area where we might want to get involved.
Thank you, Mr. Chairman. To the first one, yes, it's a group that it's an item that we're looking at. The second one, how do you make sure someone doesn't rubber stamp in effect or over rely on the outputs? That's not something that's in the scope of that group. It's something very much on my mind, and it's something that I think we need to take a much closer look at. In the context of benefits determinations, I'm speaking individually now, not like on behalf of some institution, and certainly not other members of that group I mentioned. But to me, I sense this is a very good candidate for applying a sort of customary due process of transparency. So when the government has a decision-making rubric of some kind, like maybe it's in statute, and then it's more defined in regulation, and then it's much more defined by the agencies that are deploying the systems, I think all that stuff should be 100% transparent to the point where the algorithms, at least the decisional part of the algorithms, are published as part of the rule. It shouldn't be, some public records request, and it should never be proprietary to the vendor. It's the application of the law itself, and people's rights and opportunities are at stake in this case, and it should be not beyond inspection. And so we should be able to see these algorithms at a minimum, and we should be able to run them on our own systems. And then one of the things that's great about that is if the law and the implementation of such laws were deployed that way, then people could have simulators. So they could sort of see like, oh, I've got like 2 kids and this is my situation. I made that much money last year. Would I be eligible for this or not? And they should get the same answer as the government would provide, assuming that this was truly transparent and we had sort of an open source reference implementation of it. I don't think the stuff should be hidden. It should be available and it should be replicable.
Good points. That that works for algorithmic, but does that really work for an AI conversation? And I guess this is something I haven't tried before, but if I ask the same question to GPT-4o 5 times, do I get the same conclusion each time, given the same input? I'm not certain of that. That's an interesting question. And will that always be the case? Do you have any insight into that, or is that something I should try right now?
Mr. Chairman, both. I strongly encourage you and all the members of the committee and everyone listening to try this stuff a lot and to get good at prompting and getting a feel for what the outputs are and the capabilities. It's just too good not to use as part of your jobs as legislatures and everything else. My own view on it is that that's what I was mentioning in my kind of prepared remarks, is that a lot of the existing rules with respect to algorithmic decision-making technologies assume a deterministic system. And that's what I was mentioning as well when I was talking about revealing the algorithm and letting it to be replicable. When you have these sort of non-deterministic systems, the generative AI systems, they by design can give you more than different answers every run. There's some configurations you can have with temperature and some other ways that you can kind of influence the consistency of the outputs, but they are prone to irregular outputs. And so that's a real consideration. I would not think that alone generative AI systems are up to the challenge to make a final public benefits determination. That seems like the wrong tool for the job. They can be good at doing certain types of analysis and decision support and so forth. So I think it's really not the right tool. And the only way to fully replicate that would be if the government was using an open source model, and then you could download the open source model from Hugging Face, kind of like install it the same way, ask it the same questions, and basically see if you get the same distribution of answers. And for that, you can use standard evals and benchmarks to kind of see if it's performing the same way. One of the reasons why we're bothering doing this initiative between MIT and Stanford again is because These are really interesting questions. I want to know the answer to these questions as well, and to know how far can we rely on and push this technology where it's useful and beneficial in the public sector and especially the private sector, and what are its limits and why, and where should we not use it, or where do we need additional safeguards? I think these are still largely greenfield open questions, and they require focus, especially as people just blithely go out and start using the technology for everything.
Good points, and I appreciate that. Any additional questions for Dazza on this topic? Anyone that we have online with their hand up at this point? Okay, Mr. Co-Chairman, go ahead.
Thank you, Mr. Co-Chairman. So does it kind of coming back full circle on this one? Out of the criteria that we talked about, data provenance, et cetera, that the decision-making, the human involved decision-making criteria is probably the most ripe for legislation. I mean, maybe we can try to bring that back into a little more focus of what that means in the here and now with this committee moving forward, given that we only have one more meeting in September. So with that in mind, I mean, what's the stuff that's front of mind for you in this area, in the human involved AI?
Dazza, anything that you see that we should be looking at for a December meeting, or excuse me, September meeting, or should we just continue this conversation?
Yes, Mr. Chairman and Mr. Co-Chairman, there is, and I think a really simple, narrowly focused starting point that would still get Wyoming way ahead of everyone else is actually taking another look at the Wyoming implementation of the Uniform Electronic Transactions Act in combination with the Wyoming unique legislative treatment of individual digital identity and organizational digital identity. Because one way to look at the need for human review is to look at possibly leveraging those existing frameworks and the electronic agent frameworks and the decision frameworks for automated transactions, that sort of thing, and to consider naming the individual digital identity for individuals and the organizational digital identity for organizations as having a duty when there's a key decision that's being made involving a third party to have, literally just to say, to have human review. And there's some precedence for this in the committee with the amendment to the Dow LLC Act that indicated one of the grounds for dissolving a Dow LLC is when it no longer has a remaining human being. There has to be a human involved to conduct the business transactions of an LLC in Wyoming. That makes a lot of sense, and sort of a parallel incremental approach in this somewhat broader area could also make a lot of sense.
Mr. Co-Chairman, follow up.
Thank you, Mr. Co-Chairman. Maybe we can just, before we wrap, or tomorrow or today, or when we have committee directives, we can just kind of mold that one over.
Noodle on what that would look like.
Yeah.
Dazza, did you look at the statute specifically enough to have a sense of how that might be applied statutorily?
Mr. Chairman,
concept a little bit, but
yes, Mr. Chairman, I did. I've got sort of a draft of basically a markup draft, not with final language, but I have done that, and I'd be happy to share it with the select committee and legislative council or whomever to consider it as one of the inputs.
Great. I appreciate that. That sounds good. Select committee, any other questions for Dazza? All right, Dazza, thank you for that. And I think, you know, your offer to have a reconvening of those experts that we talked to last year and have an opportunity to kind of hear updates on what's being worked on would be welcome. And maybe we can have staff touch base with you and figure out how that might work and how much time would be needed on an agenda. And if we can get that for our September meeting for a time block and just hear those updates on what you've been discussing. So we keep this on the radar and keep talking about what the newest and most thoughtful ideas are right now and what we should be looking at, I think we'd really appreciate that. Do you have any sense of, we're looking at that September timeline. I don't know what you'd think of availability or how much time it would take, but do you have any preliminary thoughts on what might be the type of presentation you could put together with us, with that group that you were discussing?
Yes, Mr. Chairman. So let's see, I got some notes on that right here. So I think it's basically time, I would think something like half an hour, given how much you have to do and it's the last session, would be appropriate. And the points that I had thought would be best are, first of all, just some basic education, going through a bunch of examples of the growing prevalence of this technology in the market and the public sector, like specific examples. And then two that I wanted to go into a little deeper, and where we have people behind them are, one is Devin, which is this amazing agent that will basically create working software programs and has 4 agents working in a team, and it's crazy. The other one is from one of the people that testified last session, John Ney, whose current startup is called Norm.ai, and he has a continuous regulatory compliance agent that he's selling, which does really interesting things. So anyway, just show you a bunch of examples of how this stuff's really playing out, and then some just to maybe kind of abstract out what are the benefits, and they are considerable, as well as what are some of the risks. I think it's the real story here is benefits, and then some ideas on how Wyoming could proactively address the technology, including encouraging its beneficial use and perhaps looking at some safeguards and protections. And the markup that I had mentioned, we're just focused on safeguards and protections, but I think the major thinking is how Wyoming can leverage this technology to get ahead, because it's available and it's underutilized in the market right now.
Great, thank you, Dazza. That sounds like a good plan. Let's plan on putting that together then for the next meeting. If you start contemplating that, it sounds like you've already done some work on putting together a good group presentation for that. We'll look forward to more on that at the next meeting, and we'll find what time works best for you during the meeting and your colleagues. So thank you once again.
Thank you, Mr. Chairman, Mr. Co-Chairman, and members of the committee. It's as always been an honor to testify before you. Thanks.
Great, thank you. All right. Following that, do we have any other public comment on our informational session regarding AI liability, data provenance, and automated decision-making issues? See anybody present here? Seeing none. Anybody online? Seeing none. Great. Public comment is closed. Back to the committee. Mr. Co-Chairman, I think we're probably still at the point of talking about this and learning, but do you have any ideas on what directions we might want to go?
Yeah, Mr. Co-Chairman, I thought that was very helpful and very informative. Maybe it's just my impulse to want to have something on paper that we can, bring to our colleagues. It might be worthwhile we only have one meeting left, but maybe it would be worthwhile for us to have a working group where we convene.
Sure. That
we show up for. Because I think the UEDA idea there might be some validity there. Maybe I don't know if I'm onto something or not, but that's out of all the conversation I got in terms of what we can turn into legislation, aside from continuing the conversation. That's kind of where I'm at per Dazza's suggestion. What do you think, Mr. Co-Chairman?
I think it's worth taking a look at and seeing what that draft might look like. We could potentially try and put something together, look at Mr. Greenwood's draft language, see how that would translate into statute. If it ends up being something that we could bring back to the select committee, we could do that at the next meeting. If it looks like it's going to be more challenging, then maybe we just come back and report, talk it through, bring the draft and discuss how we might potentially move it forward at a later time, but I think it's worth taking that up and trying to get ahead of it if there's that possibility for the next meeting. So it's a good idea. Other thoughts? How does that path sound? Trying to look at the combination of UITA and the digital identity and get some human in charge language, figure out how that might look for circumstances where you have to have a human engagement on a situation where you have an algorithmic decision. Go ahead, Representative Singh.
Thank you, Mr. Chairman. I hope that this serves as a conduit for a conversation about automated vehicles and the reality of that being a part of our industries.
So, Representative, we had, and we could potentially even bring it back, we had a really good bill on automated vehicles 3 years ago-ish.
Yeah.
Something like that, 3 or 4 years ago. That we drafted, we worked through, we did a lot of working group meeting in the interim, and then we handed it to the Transportation Committee to take, and they amended the heck out of it, Christmas treed it up, and then nobody supported it anymore.
Got burnt down.
And that Christmas tree burned down. So Wyoming still does not have a automated vehicle statute in place, and most other states do. If we wanted to bring that back and try and do it again, we've already got a very good bill draft. We could probably just bring that bill draft back and take a look at it again, see what the best practices are between now and our next meeting, and rework that. That's something that it fortunately isn't as heavy of a lift as it would be if we didn't already have the bill. But I think the bill would probably need to be modernized a little bit since it's been 3 or 4 years. So we'd have to look at what best practices are out there and potentially revise. But we worked the heck out of it. It was really a good bill. And Mr. Co-Chairman, I think we could be open to doing that. Representative Singh, sounds like you're interested in seeing that.
Go
Go ahead.
Mr. Chairman, you are correct about that.
Mr. Co-Chairman.
Mr. Co-Chairman, I think my thought is maybe give that bill a read through. And if that's in line with kind of what you're thinking, we can keep that conversation going. If not, then we can always go back to the drawing board. That would be my recommendation, Representative Singh.
Representative Singh?
Thank you, Mr. Chairman. I just bring it up because that is the type of decision making that we're talking about in a practical sense. So.
Well, I think that's a decision for the committee, whether we want to bring that for next time, because if so, we'll need a directive to get that drafted, redrafted, and then modernized a little bit, which would require a little bit of work and probably even revisiting with some of the stakeholders in the space to find out what the best practices are. Committee, what's your thought on that? Senator Ellis, do you remember that piece of legislation? I don't remember whether you were on yet or not.
No, Mr. Chairman, I wasn't on, but I just want to be mindful of our staff resources. Like I think the interim always starts out as a giant funnel and we should be working this way. And so I get a little nervous when we start going that way. So
Fair.
staff, I just mindful of their time and all the other demands of the many committees that they're servicing.
That's a good point. And we can honestly dust it off and take a look at it and see where it is a little bit and even bring that as a private bill, because it is an important issue that never crossed the finish line. The following year, the Transportation Committee looked at it again, I think during the interim, and didn't end up bringing a bill to my recollection. I'm not certain of that. I don't remember seeing it in the Senate, certainly, so I don't know what happened to it. Mr. Co-Chairman, anything else in your eyes that we want to do? I think we can work the UITA.
Yeah, Mr. Co-Chairman, I think that's probably our best jumping point. I think if we do want to put anything concrete. So at this point, I think I did kind of like the data provenance discussion, but I think Daz did a pretty good job covering the decision-making component. So I think I'm good for now.
Okay. Select Committee, anyone else have anything that we want to see? It sounds like so far we'll have a look at the uniform, the UITA and digital identity for next time, and then have some time for presentations and updates, as we heard with the working group from MIT and Stanford on what they're looking at. Anything else that we want for artificial intelligence for next time? Any of our online folks want to weigh in? Representative Yin, Senator Furphy? Any hands up? Senator Nethercott, I think, is out there right now. All right, seeing none, that's how we'll proceed for artificial intelligence for next time.